Michael Smith, Senator?
Micah, M-I-C-H.
I don't believe I know a Micah Smith, Senator, no.
Okay. I bet the victims of Micah Smith remember Micah Smith. If you don't,
Senator, there was a defendant I sentenced named Michael Smith.
Mr. Smith molested a 4-year-old girl, didn't he?
Senator, he was convicted after trial of unlawful sexual contact under Maine law.
That's a nice way of putting it.
That was the charge, Senator.
Right. Mr. Smith molested a 9-year-old. You have more sympathy for the criminal than the victim, don't you?
Senator, I worked on behalf of victims of crime zealously as a prosecutor. As a judge, I listened carefully to understand impact on victims, and I have always take that into account.
Do you know Micah Smith?
Michael Smith, Senator?
Micah, M-I-C-H.
I don't believe I know a Micah Smith, Senator, no.
Okay. I bet the victims of Micah Smith remember Micah Smith. If you don't,
Senator, there was a defendant I sentenced named Michael Smith.
Mr. Smith molested a 4-year-old girl, didn't he?
Senator, he was convicted after trial of unlawful sexual contact under Maine law.
That's a nice way of putting it.
That was the charge, Senator.
Right. Mr. Smith molested a 9-year-old girl, didn't he?
Senator, again, he was convicted of unlawful sexual contact against 2 children. In that case, I did impose the sentence the state requested.
At oral argument, this is how Mr. Smith's conduct was described. Quote, you heard this testimony. All of the abuse is done in the same fashion. Smith would rub his fingers in a circular motion on the vagina of each child, and he did so repeatedly. Now, where I come from, we call that sexual abuse. You can pretty it up all you want to, Judge. This is what you said at Mr. Micah's sentencing. These are your words, not mine. What I can say, you said, is that this is a very tragic situation of a person who has a lot of good in him, having done a very reprehensible thing to 2 young children causing extreme damage. Did I read that correctly?
Senator, in that case, I imposed the sentence the state requested.
Did I read your quotation correctly?
Senator, that I think is a portion of what I said at sentencing. My focus was on...
But the words I read, are they correct?
That's what was reported in the paper, Senator. I have not seen a transcript of the sentencing.
I bet the victims remember, Judge. You might have forgotten, just like you forgot his name, but I bet the victims remember. And then you handed down a sentence. You gave Mr. Smith 12 years, but you suspended 6 of them, didn't you?
Senator, that was at the recommendation of the state because
but it was your ruling. Is that an accurate statement of your ruling?
Senator, I accepted the state's recommendation that 6 years should be suspended so that Mr. Smith would be required to participate in sex offender treatment.
I appreciate the lengthy explanation, but I think it's a pretty simple question. That was your sentence, right?
Yes, I imposed the sentence the state requested in that case.
Are you familiar with the Bangor Daily News?
I am the Bangor Daily News, Senator.
Right. Did you read the article they wrote, quote, light sentences send a message that domestic violence does not matter, end quote. You remember that article?
I have read it, Senator. I believe it mischaracterizes a case that is described.
That article was about you, wasn't it?
My recollection, Senator, is that it described several different cases. The case that I worked on that was described there, the defendant in that case was acquitted by a jury of the most serious conduct, and that was not reflected in that article. And so
the newspaper got it wrong.
That was an op-ed that I believe misunderstood what happened, which is the jury acquitted the defendant of the most serious conduct that he was charged with. I was not the fact finder in that case, and so at sentencing I was bound by the jury's verdict.
Let me ask you, I'm going to run out of time here. I wish I had more time for you, Ms. Campbell, but I've seen a lot of activist judges, and I'm not saying you're the most activist, but the list you're on, it sure doesn't take long to call the roll. Let me finish with this question. I'm going to end as I began, Judge Lopez. You have more sympathy for criminals than victims, don't you?
Senator, I have the support of the Maine Coalition to End Domestic Violence and the Maine Coalition Against Sexual Assault. I believe that support is a reflection of the work I did as a prosecutor, as well as the care I take with cases involving victims as a judge.
You're embarrassed to answer my question, aren't you?
Thank you to the nominees for being here. I'm sorry that I was unable to preside, but in the capable hands of my colleague, Peter Welch. Judge Lopez.
It began with a blade of a question, sharpened by repetition and aimed with prosecutorial force. You have more sympathy for the criminal than the victim, don't you? Senator John Kennedy didn't circle the target. He went straight for the heart of it. Judicial temperament, moral priorities, the question of whom our justice system is built to center when the harm cannot be undone. Across the witness table, the judge, measured, composed, recited a life's work on behalf of victims, first as a prosecutor and now from the bench. But Kennedy cut back in, naming a defendant the judge did not immediately recognize, Michael Smith. And then he delivered the line that drained the oxygen from the room. I bet the victims remember. In that instant, the hearing cracked open and showed us what is always underneath, the ache that lives beyond legalese, the memory that does not forget. Kennedy pressed the facts. Smith was convicted under Maine law of unlawful sexual contact against 2 children, a 4-year-old and a 9-year-old. The senator refused the euphemism. Where I come from, we call that sexual abuse. You can pretty it up all you want to, Judge. He read from the record of conduct, the circular motion of fingers, the repetition, the pattern, and refused to let the detail drift into abstraction. And then he read the judge's words at sentencing as they were reported. A very tragic situation of a person who has a lot of good in him, having done a very reprehensible thing to 2 young children causing extreme damage. That juxtaposition, a lot of good in him set against reprehensible harm, was the fulcrum of Kennedy's case. The judge explained, the sentence imposed matched the state's recommendation. 6 years of a 12-year sentence were suspended to facilitate sex offender treatment. The phrasing was drawn from a longer statement. The transcript wasn't in hand. She noted the Bangor Daily News op-ed. Light sentences send a message that domestic violence does not matter, and said it mischaracterized a separate case in which a jury had acquitted the defendant of the most serious charge. She emphasized her credibility with victim advocacy organizations in Maine, and still the senator came back to the same hard question. It was your ruling, wasn't it? You gave Mr. Smith 12 years, and you suspended 6. I bet the victims remember. What did this moment reveal about government, justice, and the moral weight of the robe? It revealed the blunt force of accountability colliding with the slow, imperfect craft of judging. It revealed a hearing room as a crucible where 2 duties, mercy and protection, are heated until one of them yields. Kennedy's challenge was simple and devastating. Do our courts speak the language of victims first, or do they fluently toggle between the vocabulary of harm and the vocabulary of rehabilitation in a way that makes justice sound like distance? The judge's answer, equally serious, was that law must be anchored in procedure, in recommendations, in the constraints of the record and the verdict a jury has actually returned. She stood on the bedrock of due process. He stood on the graveled path of memory. There is a deeper paradox here, one that lives at the center of American justice. We ask judges to sentence not only acts, but people, to hold both the injury done and the possibility of change in the same weighing hand. If a judge acknowledges that a defendant contains a lot of good, is she betraying the child who will bear the scar? Or is she practicing the only justice a republic can endure, the justice that refuses to declare any person a sum of their worst moment, even as it refuses to minimize the pain of the innocent? Kennedy's interrogation demanded an answer that left no air between sympathy and consequence. The judge's defense insisted that consequence, to be legitimate, must be tethered to law, evidence, and the recommendations of those charged to argue on the state's behalf. But hearings are not seminar rooms. They're moral stages, and on this stage, the senator's line, "I bet the victims remember," functioned as more than rhetoric. It was an indictment of a system that too often speaks in codes: unlawful sexual contact, suspended sentence, treatment, mitigation. Each of those terms has meaning, each does real work, but each also risks sounding like the softening of a scream. Kennedy refused the softening. He accused the judge of forgetting even the name attached to the pain. She pushed back. She remembered the case. She imposed the state's ask. She was bound by the jury's acquittal on the most serious charge in another matter. She pointed to the coalitions against domestic and sexual violence that stood behind her work. He pressed the moral ledger again. "You're embarrassed to answer my question, aren't you?" Leadership, at its best, puts competing truths into collision so the public can see the sparks. This exchange did exactly that. It told a story about power, the power of a senator to frame the narrative, the power of a judge to be restrained by process, the power of newspapers to harden a perception with 4 words. Light sentences send message that can burn into civic memory regardless of nuance. It told a story about responsibility, the responsibility to victims who live every day with what the court can never restore, and the responsibility to a legal order that must sentence with blindfolded integrity, not with political heat. And it told a story about us, about whether we still expect justice to be both certain and careful, whether we can tolerate a system that names evil without erasing the human being who committed it, whether our hunger for moral clarity can coexist with our need for legal rigor. Kennedy's anger was real, and it captured a nation's impatience with outcomes that feel, in the marrow, too lenient for the harm suffered. The judge's insistence on process was also real, and it captured the hard-won wisdom that sentences made for applause are rarely the sentences that endure. So the gavel fell, and the chair thanked the nominees, and the hearing moved on. But the question did not. It hangs now where it should, in our homes, in our courthouses, in our policy-making. How do we honor victims with more than words and punish offenders with more than symbols without abandoning the constitutional spine that keeps judgment from becoming vengeance? The answer cannot be a slogan. It must be a standard, clear, enforceable, and worthy of the trauma it is meant to address. Remember this moment. Remember the names that were stumbled over and the facts that were not. Remember the line that cut through the noise. I bet the victims remember. In the end, justice in America will be measured not only by the sentences we hand down, but by the care with which we carry the pain of those who never get to forget. This is Congress Signal, where hearings become history, and history demands moral clarity. Subscribe to Congress Signal, Support our work so we can keep the cameras on, the questions sharp, and the truth in the light.